So Sandra, go ahead.
Yes, I was calling. I'm wondering, my daughter has a child. There's not a father listed on the birth certificate. There's not a father in the child's life. And she is wanting to have something done to where something was to ever happen to her, I could get legal custody of my granddaughter. And we kind of don't know what we need to do to make that happen, if we need an attorney or what we should do.
So Chandra, thank you for the question. Essentially, you want to know who the guardian is going to be in the event, in the unforeseen circumstance your daughter passes, so your granddaughter, has a guardian already appointed. I will tell you that is outside of my wheelhouse, so I'm just going to go ahead and throw it to Erin because that is something she hopefully has dealt with before, and you can kind of walk Chandra through that.
Yes, I have dealt with it for a little bit. It's still something where it would be beyond probably what I can answer at least today, but it is something where generally you want to maybe have a will, or your daughter have a will outlining what her wishes are. I'm not aware of something to go ahead beyond that right now. But there are documents that you can normally do, power of attorney, healthcare surrogate, or in case there's something that happens if your daughter is still alive. But typically putting those in a will would be at least to outline what her wishes are. And then of course consulting with a probate attorney afterwards, or to for additional information to really make sure that that's set up correctly.
And in Florida, just to add on, if a will is the appropriate instrument to make sure that the daughter is, your granddaughter would be watched after by the party that your daughter wants to take care of her in the event something happens, 100% you need to follow the rules in Florida. We have very strict rules for wills. For instance, I think there has to be, correct me if I'm wrong, 2 witnesses. Mm-hmm. So if one witness is there or there's no witnesses, it can be what she intends to do, but the will would not be in effect. And I know I've ran into this a few times where somebody is taking care of a child, but they have no actual legal rights. They are doing everything proper, but I can't actually represent that person on behalf of the child because that person has no legal rights. So it sounds like you guys are taking an affirmative step in the event something is happening, or if your daughter is sick, or just to make sure, the child or the grandchild is watched after in the appropriate way, because in that circumstance where it doesn't happen, let's say your daughter were to pass and you were to just take your granddaughter in without any court documentation. If she then has a legal claim, you would be the one who would have to pursue it on her behalf, but you would have no legal standing to do so. Nobody would. So to make sure you take appropriate steps, whether it's a will or a power of attorney, whatever it is, that is exactly what you should be doing. So that is a great question. But as always, if you have a legal question, it's best to meet with a lawyer. Having a will or a power of attorney is relatively cheap, and that will make sure whoever it is, their wishes are outlined properly and nobody's fighting over the kid after the fact.
Even if it's not just a personal injury suit, but also just to enroll a child in school, you might be going to need that documentation, and just checking with an attorney and making sure that you're following all the right steps. But that's great to hear you're already being proactive and already thinking about it. And some people sometimes wait till it's too late, so it's good to hear that you're being proactive.
And then it gets complicated. I think another situation where people want to take care of things beforehand is, I know we've talked about this before the show went on the air, but a prenuptial agreement. So for those who are considering a prenuptial agreement, should both the husband and wife go meet with one attorney? Should they get separate attorneys? What is the process where people are considering that and they want to make sure, hey, if something unforeseen happens in the future, we're not going to argue about anything, we're going to figure it out now. What would be the process for that? Should both people come and see one attorney?
I would not recommend you both seeing the same attorney, but I think prenuptial agreements are great for people, whether you're a millionaire or you're just starting out, post college and you just got a little bit of money. It fully outlines what you're going to do in the, should you separate, what is your property prior to, what is their property. But your interests are going to be adverse to one another when you're doing a prenuptial agreement. So I definitely would recommend that each party meet with their own separate attorney individually, and then working out those terms in a settlement agreement, utilizing those attorneys for their help. But I think they're great. I do think that they help kind of set the tone. Nobody really wants to talk about it when you're getting married, when everything's great, but it's better to go ahead and work out those things when everybody's getting along and has somewhat of a level head.